first up is our estate planning session. It's a holiday favorite as we look forward to the future. And sadly, none of us is getting younger. We want to make sure that as we mature, that those of our pets that are possibly going to outlive us, outlast us in terms of our abilities to take care of them are handled appropriately. I cannot tell you the number of times at Mickaboo where we've had emergency phone calls from caregivers or relatives of somebody that is going into assisted living or has deceased. What do we do about these birds? As opposed to some folks who actually have planned very well for them, who have had pet caregivers lined up, who have had rescues and sanctuaries lined up, who've put aside a certain amount of money to take care of the monetary needs of the birds while they're finding their newer homes. So the focus of this particular segment, which will be now 29 minutes, is going to be on the legal stuff, which is so important, that should be in place for yourself and your pets to make sure that that time is not aggravated in terms of frustration at that point. So Alyssa, who's going to be coming here, has done this presentation for us for a few years. Thank you, Alyssa. And we also want to say that this recording will be available after the session, as well as her PDF. In recognition of the fact that due to some scheduling things, this is a half-hour presentation as opposed to the normal full-hour presentation. I say the contact information for Alyssa is at the very end of the presentation, and we at Mickaboo will be happy to help you there as well, to put you in touch with Alyssa. So without further ado, let's welcome Alyssa. Yay!
Thank you, Pam. Well, I'm happy to be back again. I think this is my third year in a row doing the presentation. So always good to be back and chat with everyone about, in particular for today, it's going to be estate planning to protect you and your beloved pets. I know it is, like Pam identified, it's always a good idea to start thinking ahead. Even if, you're still spry and young, really anyone over the age of 18 would want to consider setting something up for themselves. And in particular, the way that our legal system is set up is not always conducive to taking care of our pets or companions. So part of what we'll be talking about today is going to be the ways that legally you can set some documentation up to help protect both yourself and those pets. Oops, sorry. I'm working on this slideshow here. Okay, so a little bit about myself. I am headquartered here in the Sacramento area, but I do provide legal services to lots of different communities throughout Northern California. The nice thing about modern technology is that, you can have Zoom, you can have telephone conversations. There's a lot of different ways to get the information out there. So if anyone has any questions, while I do provide services in estate planning, I also am versed in probate law, conservatorships, and general estate administration. So just to kind of kick it off, I always like to start off with what really is estate planning to begin with. A lot of people don't realize it, but they're probably already doing some form of estate planning when it comes to beneficiary designations for things like, regular bank accounts, if you've done that, maybe some retirement style funds like IRAs or life insurance. And so overall estate planning is really trying to determine what happens with your assets upon your passing. There's some other considerations there as well, but a lot of people have probably already done some form of estate planning through beneficiary designations. Another type of estate planning would be taking title to property. So that would include bank accounts, real estate. The way that your name appears on those types of assets are really going to determine what happens to the assets, either upon your passing or if you ever do become incapacitated. But really, our focus for today is going to be on those legal documents that are really critical in letting you take control and determine sort of what your preferences are for if you do become incapacitated or if you pass away. Primarily, we'll be talking about revocable living trust and what we would refer to as a subtrust under there, which could be a pet trust. So we'll talk about that. Last will and testament as a pretty common type of document that I think more people are familiar with than a trust. Durable power of attorney for finances and advanced healthcare directive, we're not going to talk about today just due to timing, but those are going to be those four documents being the trust, will, power of attorney for finances, and a healthcare directive tend to be the four primary documents that most people include in a formal legal estate planning portfolio. All right. So who needs estate planning? Like I identified in my introduction, really at a minimum, every adult who's 18 and over should at least have a durable power of attorney for finances and an advanced healthcare directive on the medical side. Really just because you never know what's going to happen during lifetime. As we'll talk about a little bit later, a lot of the default rules too in California are not always conducive to making sure that our pets or companions are supported in the event of our own incapacity. And so, one really good way to help yourselves and your pets would be to set up your own powers of attorney for finances and healthcare, essentially to make sure that they are taken care of appropriately in the event that you either become temporarily or permanently incapacitated. A living trust, on the other hand, is mostly going to be appropriate for a couple of the following situations. So, a lot of people are going to need a living trust if they have any minor beneficiaries. So, that would be anyone under the age of 18 who they might want to leave assets to. For our purposes, it's more so we're focusing on beneficiaries who cannot manage money on their own. So, our beloved pets and companions are not capable of independently managing any funds that you might want to set aside for them. And so a trust tends to be a really good way to set things up so that they are supported with someone else managing that money for them. And then also, just as a general category for trying to determine whether a trust is going to be appropriate based on the types of assets or amount of assets that you have. In California, the current value, which is a little bit of a moving target because they change that number over time, but if anyone were to pass away at the current rates, if your estate is worth over $184,500 in value, and or you have any real estate, particularly in the Bay Area, you're most likely going to want to consider doing a living trust because that's going to be the easiest legal document to set things up for whoever you leave in charge to be able to somewhat efficiently be able to access and then manage your assets for you. All right. So what happens in California, though, if you don't have any legal documents at all? In many cases, it can be quite an uphill battle, and we'll touch very briefly on what probate looks like and why you would want to do something like a living trust in your own estate planning documents. Probate itself is a very lengthy process. So in most cases, because courts are very backed up and there's a lot of cases that come through on a day-to-day basis, depending on what county you reside in, or the person who passed away, I should say, what county they resided in at the time of their passing. Most probates are going for somewhere between 9 to 12 months, meaning that a lot of people have to wait, or whoever your heirs are or intended beneficiaries are, would have to wait up to 9 to 12 months on the shorter end in order to receive any inheritance. And so, particularly with our pets, that can put them in a bind because you're in almost a period of limbo where no one has any authority to help take care of them. And so, you're kind of relying on the goodness of your family members or any other friends who might be willing to step up in the interim to help support them. And so, it's a very lengthy process. It is not quick. Probate can also be quite expensive. I won't go too much into what the court costs and attorney's fees are, but just know that the cost of doing a trust is going to be significantly less than it would cost to have to go through a full probate administration because there are statutorily calculated fees and other required fees that go along with it. And then the other issue with dealing with the probate court is that it's quite public. So the majority of the documents that get filed in a probate, if someone were to pass away and had no legal documents at all, um, the information about who their closest living relatives are and what the assets of their estate are, all of that is mostly public record. And also nosy people nowadays can just log on to what most courts do, which is a Zoom hearing, and they can listen in on and possibly get information about the estate that maybe you wouldn't want other people to know about. So while probate is not an insurmountable sort of venue to have to deal with, it's also not ideal because it takes quite a long time, can be quite costly, and is not a very private process. The other common misconception that I hear, or one common misconception that I hear among a lot of folks is that, well, okay, if that's the situation, and if I had no estate planning documents and I'd have to deal with probate, then why don't I just do a will? And unfortunately, just having a will doesn't necessarily avoid probate. If you just did a will, let's say you didn't do a trust at all and you thought, great, let's just do a will, specify what I want. The unfortunate situation is that if you do fall into that asset category where your estate is worth over that sort of current number of $184,500 in value upon your passing, then the probate court is the only entity with the authority to oversee the administration of your estate. So while you are taking control to a certain degree of, who's in charge of administering your estate and where your assets ultimately are going to be routed to so that you're not stuck with all of the California default rules, you're most likely going to have to deal with the probate court system. So just a will in and of itself is not always the best tool, which is why you really want to maybe consider doing a trust. So just as a quick recap, the difference between a will versus a trust. With a will, it's going to only be effective upon your passing. So it's not going to do anything for you during lifetime. And it will likely require probate if the value of your estate is over that particular value, that 184,500. Again, it's a moving target number. So that's just our current valuation in California. A will is also going to be very public, and it would be its own sort of standalone document that you'd be relying on for all instructions for administration. On the other hand, if you consider a trust, some general benefits of doing a trust would be that it is effective during lifetime, so just in case you ever became incapacitated, but it also has all of the instructions for how things should be managed post-death. It doesn't necessarily require probate. Now, there's some situations where people who do a trust end up in probate court because of ambiguity or because something strange comes up or somebody contests the trust itself. But for the most part, if you do your trust appropriately, it should be able to be administered privately. Okay. And with a trust, you don't actually have a separate set of instructions where you've got a will that basically has its own, specifications of who's supposed to manage and where things go. Really, it has just what's called a pour over will. And that pour over will serves as a backup to your trust. So it's almost like a catch-all. You're hoping that if you do forget to put something into your trust, like an asset or an account, that if you pass away, then that pour over will scoops it up and pours it over into your trust so that all the instructions that you've painstakingly put together into your trust will actually apply to those assets. All right, and now to get into the topic, the part that everyone is tuning in for today. What do we want to do in your documents to help protect you and your pets? Now, with your revocable living trust, really it's just going to be a legal contract, right? So during lifetime and after death, you can always make changes as far as the terms that you put into that trust for your support and for your pet's support. But really the best, I would say, functionality of a trust is that it really serves as a legal key to the person you leave in charge, otherwise known as your trustee. And it allows that trustee to access the assets that are properly connected to your trust. So for example, if you have a medical event where you can't manage your trust anymore, or even if it's a temporary situation, your successor trustee would have very clear instructions under your living trust for how to access and be able to manage any bank accounts that you have that are connected to that trust. And then they can use those funds to pay your bills, make sure that you and your pets are continuing to be supported. All right. Now, during your lifetime, your trust specifically, you'd want to consider including language about supporting you in that event of incapacity. Most standard trusts do not have any of the necessary language to protect your pets. Typically, it's going to default to only protecting you and you as the primary beneficiary during lifetime. So it's important if you're putting your documents together to also consider and let your estate planning attorney know that you've got some pets who would need and have care needs that would need to be financially provided for. So when you're doing your documents, it's a great opportunity to incorporate some very specific language so that you can also give some guidance to that trustee for how funds should be used for the benefit of your pets. For example, if you've got a pet that has a lot of healthcare needs and has a particular vet or healthcare plan, then you would want to be able to incorporate some of that language and allow your trustee to use funds to support that pet for those medical needs. And of course, the trustee is also going to have to be weighing your needs as well as your pet's needs. But rather than just sort of leaving it up to the defaults of most trusts and most legal documents, you are adding in that specific support language for them. And then post-death, your trust can also provide instructions for the distribution of your trust assets for your desired beneficiaries, whether that's individual people, or in California, this also could include a pet trust for your pets or companions. All right. So what is a pet trust? How does this thing actually work? How does it get set up? Typically, your pet trust is going to function as what we refer to as a sub-trust. So really what that means is you've got your main trust, which is like the umbrella document, right? It's got all your instructions for what happens during lifetime and post-death. Maybe you've got some language in there that says that a particular person or organization should receive some sort of distribution or inheritance through your trust. But if you want to set aside a certain amount of money or allocate a percentage of your overall trust estate to the support of your pets, a nice formal way would be to set up this sub-trust so that it branches off from that main umbrella trust and has separate instructions about how that pet trust should be administered for the benefit of your pet or companion. Now, the trustee of your trust ultimately will transfer whatever that allocated fund or asset is to the pet trust. And then from there, that pet trustee continues to manage those funds for the benefit of the pet. And then upon the death of those pet or multiple pets, then you can choose where the remaining assets from that pet trust, if any, should be should be distributed to. Now, some pet trust considerations. This is kind of the meat and potatoes of when you're considering doing a pet trust. And this would be if you go that formal route of truly setting up that sub trust where funds are allocated to with a trustee managing it for you. So one would be identifying the pet. Is the intent of the pet trust only to do the pet trust for a specific pet, meaning one that you currently have? Or do you want to kind of leave it open so that there might be this pet trust that is set up for any pets that are living at the time of your death? It kind of depends on the preference of the client. I typically have the conversation with my clients about, whatever you're allocating to this trust, or is it because it's really only for, your pet that you currently have now? Or do you want to set it up in a much more flexible way where if that pet were to pass during your lifetime and you were to adopt another pet later, that, okay, do you want these same instructions to still apply to that later adopted pet? Keeping in mind that the beauty of a trust, a revocable living trust, is that you can always make some changes as time goes on. So even if you did originally set up your trust for one particular pet, if that pet were to pass away and you were to adopt another pet later, you could always amend the terms if you don't quite feel comfortable leaving it as like an open-ended any then living pets category of instructions. All right. And then the other consideration that you want to start thinking about if you're considering a pet trust is the amount that's going to be held in that pet trust. A couple of things that I talk with my clients about would be, considering on a yearly basis, what does it typically cost to take care of a healthy pet, right? So, what are their regular exams? What about insurance, enrichments for them, food, kind of the necessary items, but then also the things that make their lives happy. So, just you would know best at that point. And then also trying to figure out, okay, if we know what the yearly costs are for a healthy pet, what is also that pet's potential life expectancy? And that helps us get to a comfortable number if we're thinking about a particular amount of funds to allocate to the pet trust for that pet's benefit. And then the other consideration when we're thinking about the amount to hold in a pet trust is also for that particular breed of pet, if you think that, if we're limiting it to just the pet that you have right now or opening it up to any then living pets that you might have later, if you're thinking about holding on to that particular or keeping with that particular breed, um, do they have any particular health issues that come up or very common health issues? In which case, you may have considered a healthy pet's financial needs, but what about a pet that is more likely to develop cancer or another illness that may require much more significant financial care? So some things to just consider based on that need. The other big consideration is going to be who your pet trustee is. All right. So I think this is other than the amount, trying to figure out what the amount is that you should allocate. Choosing the pet trustee tends to be the biggest sort of sticking point for a lot of clients. More often than not, you're going to want to consider that person very carefully, right? Because whoever you choose, they may be the person who is going to continue to live with that pet for the remainder of the pet's lifetime, and they're the ones who's also managing the funds for the pet. And so, if that's the case, you want to make some considerations as far as has this person ever taken care of this type of pet before? Has this person, are they allergic to this type of pet? Do they have the living environment that would be conducive for this pet to reside in? Also, taking into consideration organizations like Mickaboo, you would return the pet, right, if that were the case. But if you did not get your pet or adopt your pet originally through an organization like Mickaboo, just thinking if that pet trustee is going to be taking care of that pet, are they the best person to choose? So I would say just kind of consider whether or not that person would be appropriate. Sometimes people also will choose, in addition to a pet trustee, what's known as a pet enforcer. So the enforcers could be like a third party that could step in at some point and hold that trustee accountable for how they are using the funds. So that could be something to the effect of requesting an accounting of how the money has been either invested or utilized for the pet, and just making sure that everything is still going according to the terms of the trust. That's a little bit more of an additional administrative layer to add on to there, but something you might want to consider. And then finally, another consideration for the pet trust would just be, what do you want to do with any remaining funds after the pet dies? Sometimes people consider leaving the remaining funds to the pet trustee. Sometimes, to avoid a potential conflict there, they may decide to leave the remaining funds to an organization like Mickaboo or any other nonprofit or family member or what have you, right? So it is an important conversation to have, though, because we want to make sure that any remaining funds are directed appropriately according to what your wishes are. All right. So overall, what are the benefits of formal estate planning? Hopefully you can avoid any sort of probate court involvement with the administration of your affairs. It's supposed to be an easier administration because you've provided easier access for your successors to be able to manage and control any of the assets that you intend to flow through that trust. And it just adds a little extra protection if you're adding in those extra provisions about support in the event of incapacity during lifetime, and then, of course, post death as well. You do get that certain level of privacy so that without the court involvement, hopefully everything is administered privately and just kept sort of in-house in a small universe of individuals, and it can be quite efficient. Now, the only other thing I will point out is that we've talked in length today about a formal pet trust where there is a sub-trust that's created. But in some situations, I have some clients too who decide to do something a little bit more informal, meaning that we still do a living trust for them. But rather than a sub-trust that branches off from their main trust, they may decide to just set aside a donation for an organization like Mickaboo, where upon the client's passing, and the birds are returned to Mickaboo, for example, then that fund can be allocated to back to Mickaboo as a donation. And then and are confident that Mickaboo is appropriately going to help continue the care and possible replacement, right, for that pet with another home, loving home. Lots of different options there. Each situation is a little bit different. Each client's preferences are a little bit different, but at least, we've all kind of had a chance to talk about what the options are and what the legal documents are that are available to help you achieve those goals. With that being said, I do apologize. I know this was a faster presentation than we normally do, but if anyone has any follow-up questions, I know I'll have a couple minutes left to answer any questions that might have been submitted. But feel free to email me. My email address is at the bottom there, alyssa@chowtrustlaw.com. I'm offering free consultations as well. So if anyone, has any follow-ups for that, please reach out. And thank you so much for having me.
Thank you, Alyssa, again for joining us. I know you're going to need to pop off in a couple of minutes. We don't have any open questions at the moment. If anybody does have a quick question for Alyssa, please feel free to throw them into Q&A real quick. One thing, Alyssa, that you mentioned was about the donation idea at the very end. And one note that I've often heard from people in your position is that the document should specify whether, excuse me, the donation should follow the bird, as when we adopt, excuse me, the bird out to a permanent home, or whether there is some portion that stays with the organization. And of course, the document can allocate money for both, right? Is there anything you'd like to add on to that?
No, absolutely. Yeah. So that would be something else, depending on the goal of the client, that we would want to specify, just so that there's no ambiguity about where that donation should flow through to.
Yeah. And then the other thing that I will add on to your remarks is that, to the extent that you're making these decisions about people or entities to take care of your pets, please, make them aware. Make them aware ahead of time, because
Yes.
I can tell you from personal experience with my parents that the hours and days after someone's passing are chaotic, to say the least. And so the more that is known and somewhat top of mind, wills and other paperwork might be locked away in a safe deposit box, and somebody's got to go find a key, and which bank is that? Maybe they know where your estate lawyer is, and can call Alyssa and say, hey, do you have a copy of that document?
Right.
But particularly for living pets of the household, where decisions may need to be made quickly so that they can continue to be fed and maintained, you want your pet caregivers to be top of mind for those who are going to be most aware of your passing immediately thereafter.
Yeah, absolutely. It's and also just that's a great point, Pam. I would say as well that before you designate someone as your pet caregiver or pet trustee, that you do want to make sure that you get their green light from them ahead of time, so that they also aren't entirely surprised that they've been put into that role as well.
Yes, indeed. Okay, I don't see other questions for you from the audience. So for the audience that might have joined a little bit later, this recording and this slide presentation that Alyssa has made will be made available publicly. We're going to need to process it first, so give us a couple of days for that at least. Alyssa's contact information is right there on the screen, and again, we at Mickaboo will have that. If you need to, I see a hand has been raised somewhere. Stega, what is your question? And let's see if I can actually unmute you. Allowed to talk. Okay, go for it.
The chat window is saying that it is disabled and I'm unable to actually type in the chat box. So others may be experiencing that problem.
Okay, we will take care of that with Sarah, but what questions?
Oh, but I forgot the question. Oh, yes. And make sure you let Mickaboo know if they are part of your estate planning and get them your documents.
Yes, absolutely.
Yep. All righty, Alyssa, thank you again so much. I know you need to run, and we'll take it from here.
All right, thank you. And excellent event as always.
Thanks again.
All right, thank you. Bye-bye.
Okay, you take care. Okay, so Alyssa is going to stop sharing. Yes, okay. And let me, so to just carry on a little bit from what Alyssa mentioned and what Stega also mentioned, and Sarah, if you're around, if you can make sure that our next presenters will be able to get questions from the audience, that would be fabulous while I sort of chatter on a bit here. Back to carrying on a little bit from Mickaboo's perspective about the arrangements for Mickaboo birds. We are happy to get care instructions from you ahead of time. Let's say that you've got, a double yellow-headed Amazon who has to be covered at night, and here is his diet, and he is bonded with this other bird, stuff like that. I mean, we are happy to get that kind of information from you ahead of time. Also, if you want to make us aware that we are indeed in your document, be it a living trust or be it your will, we're happy to keep you, on file, as it were, so that when your lawyer connects with us, we have an easier conversation as opposed to trying to trace back, who are we talking about and what are we doing here? That sort of idea. So we are all good there. And can someone try the Q&A button now to see if that is working for us? That would be fabulous. I'm going to pause a second while somebody tries to do that. Okay, Henry, thank you for doing that test. We do see that particular test come through. Thank you very much for that. Okay, so while I'm on the subject of the estate planning, before I go into auction mode, are there questions that people might have about Mickaboo's perspective on the whole planning ahead for your pet idea? I'm going to pause for half a second. And that's half a second. So basically it's, tell us, if you can, that we are in your document. If you need wording, obviously your lawyer is going to be in the best position for that wording. They will often need our full formal name, Mickaboo Companion Bird Rescue, as well as our EIN, and a way to contact us. We usually suggest our email address, mail@mickaboo.org. And our phone number is around, but the email address is probably going to be the most permanent way, as much as anything is permanent in this world. There is also the general suggestion to have a backup in case Mickaboo were to, God forbid, go out of existence, because we're talking about something that's potentially 20, 30 years away if you're starting to do your planning when you're very young here. I see a question that Sarah's going to answer here about non-Mickaboo birds that might be left behind should something happen to you. And Sarah, would you like to take that?
Hello. Yeah. Yeah, we get contacted fairly regularly by people who are thinking about future plans, and they're often people that we have never met before. And they will say, I have a couple of birds, or I have 3 birds, and I'm looking at my options. And so, yeah, they're usually not Mickaboo birds. I think people that have Mickaboo birds know that Mickaboo makes that lifetime commitment. So if you ever adopted your bird from us, we kind of stipulate that we will have to take them back. So it really is only non-Mickaboo birds where people are likely to reach out. Although we're always grateful if adopters leave something to support our work and the care of their birds once they do end up coming back to us, if that happens. So yeah, we get inquiries, and we have standard information that we share back, with our EIN number and other details that we recommend that you include in any wording to make sure that we're easily identifiable and contactable, as Pam was talking about just now. Probably the most helpful thing that you can do is to nominate some people who might be able to help with transport. Depending on where you are, the further out you are from the Bay Area, the big challenge is going to be pickup. And also confirming that you have put us in your estate plans, and also giving us profiles of your birds and their care, what they're eating, their situation, their routines, anything that helps with making sure all of their needs will continue to be met. We get a lot of people who send initial inquiries, and then we don't hear follow-up about what they decided to do. And we only have a name and a city and an email address. We don't have a physical address, which could obviously slow down logistics if something did happen. And we don't have much detail about the bird's care. So we have a database we use to save profiles on everybody we work with and all the birds we care for. We'll save your information in that database along with profiles for your birds. You can send us PDFs or Word files, and we'll save all that information. And then any Mickaboo volunteer with access to the database can look that up in the future if need be. So that will be saved in perpetuity. And it doesn't matter who you share it with. We'll have it in the system. So yeah, the more information you provide when you make your inquiry, the better chance we can help if the time comes.
Okay. Thank you for that question, Bill, and that answer, Sarah. I do see another question about Mickaboo's EIN, since we've now mentioned it twice. The EIN is public information, and sadly, I can tell you it from the top of my head.
You
it's
can literally
9432863444. Let me throw that into something like chat.
You can literally go to Google and type Mickaboo EIN, and it's the first thing that comes up. There's a number of nonprofit directory sites that list it. Google indexes it. It's very public information. I would encourage you to double check it against those references, because getting it right obviously is helpful.
Yeah, I will also mention that Mickaboo's Form 990s, Form 990 is the nonprofit version of the tax return that we all file reluctantly with the IRS. And there's a fire truck going by. I'll let that go first. Okay, there we are. So Mickaboo's Form 990s with our EIN is now posted to Mickaboo's website. So that's another source. And of course, IRS keeps a database of charitable organizations, because that's how they know that anything is tax deductible to a particular organization or not. So there's multiple places. And of course, you can always email us. We are happy to answer that. I mentioned that I would put the EIN into the chat. I have done that. So that information is now available to those of us who are on the call. The best way to send an inquiry to Mickaboo, our general email address is mail, M-A-I-L, at mickaboo.org. That particular email address is monitored by a number of very knowledgeable people, and we will get back to you as soon as we can. This week, I will say we're probably going to be slowed down a little bit because of this thing called the auction.
I will say the contact form is also super helpful because we get a little bit more information from you that way. So I'm going to put a link to the contact us form in the chat as well. That is definitely, that's a little bit better than emailing us. I mean, they both work, but we get a little bit more info to save about you if you use the form. And it's also, we have a little subject choice option there. So your inquiry will get to the right person just a little bit faster.
Yep. Okay. Great. Just checking for additional questions here. Looks like we're good on the estate planning questions.
Maybe just one thing is worth highlighting for people who haven't read our 990s, even though they are on our website now. Estate planning is one of the pillars that has financially provided for Mickaboo to prevent us from going into moratoriums more regularly or struggling to financially support the care of our existing fosters. So estate planning really, I know it's not something we think about very often, but it's really important to do for your own family and plans. But also, if you do care about Mickaboo's work, it's an incredibly helpful thing for you to consider including. And it's one of the things that has allowed us to continue functioning relatively uninterrupted for most of our 26 years now, I think. And it really, it makes all the difference. We've been very fortunate to have some very generous gifts that have sustained us through harder times. And we are incredibly grateful for that because it allows us to continue doing what we do.
Indeed.